Good morning. My name is Brent Pohlman, and I'm a partner in Mandelbaum Barrett's corporate group. I focus on labor and employment practices. I'm here today with my partner Gary Young to discuss an important issue that all employers need to be aware of.
Yes, and of course, I just to add to that, I've also practiced in the employment law area. And we're talking about something today that I think is concerning for all employers, not just unionized workforce employers, but even non-union employers.
So Gary, the National Labor Relations Board recently adopted a more stringent decision governing the interpretation of workplace rules in their Stericycle decision. This replaces a 2007 decision arising out of a Boeing matter that applied a more employer-friendly or a more reasonable interpretation standard. I guess my first question that I think employers out there want to know is, where does the NLRB's authority to govern non-unionized employers arise from?
Okay, so this is a very common misconception among people in general about the role of the NLRB and its jurisdiction. Section 7 of the National Labor Relations Act guarantees rights to both employers and employees. Often employers are forgotten about, but we're talking about employee rights under Section 7. And generally people think, well, okay, I don't have a union, I don't have a union organizing campaign, I don't have to worry about it. The truth is, more and more the NLRB is exercising jurisdiction over activities of non-union employers, and this Boeing decision stood for the proposition that the NLRB would balance the interests of the employers and the employees and interpreting their rules. Well, in more recent times, we've seen a marked transition away from that and to where now we're getting into a very subjective test as announced in the Stericycle case.
So focusing on Stericycle, the board stated that it is now presumptively unlawful to have a policy or a rule in place that could be interpreted as infringing upon employee rights as guaranteed in Section 7. What are your concerns about this new standard, and where do you see it becoming an issue for employers?
Well, I think this is a very surprising and I think incorrect movement in the wrong direction, because we're talking about policies that you would typically find in an employer's handbook. And in fact, in this particular case, we're talking about maintaining confidentiality of workplace harassment claims, which normally, and it would be a given, of course, that should be confidential. However, if it could be construed as having a chilling effect on Section 7 rights, which is the right of employees to gather collectively to assert their complaints in the workplace, this could mean that policy, even mandated by the states in many cases, might be deemed to be unlawful.
So let me ask you this question. A lot of employers are going to hear this and they're going to say, why even have an employee handbook if it could give rise to liability under Section 7? And what should I do going forward? What would you say to them?
I would say that the knee-jerk assumption that I can have a handbook, I can have policies, and that it's my say, and that rules here, has to be tempered by this. However, that does not mean that we throw all of our policies out the window. We have to look critically at what the handbook says, what are the policies saying, and basic question, is this really necessary? Is it, or can we say it in a way that perhaps is going to be less subjectively chilling? Because that's what we're dealing here with, is a very subjective feeling that it may tend to chill an employee's rights, which, how do you deal with that? I mean, it's just, it's so nebulous in terms of that.
Well, I think that provides an overview of the recent decision arising out of Stericycle, and we would encourage all employers who have an employee handbook and don't have an employee handbook to contact Gary or myself, and we can guide you through evaluating whether or not your policies are compliant and help you create policies that are.
And let me just point one thing out, because a lot of people do not understand procedurally how the NLRB works. We're talking about an administrative agency, and you have almost like a prosecutor. An unfair labor practice parallels a criminal charge. So you have a prosecutor, you have an administrative law judge, and then you, the employer, have to defend perhaps these charges. And I would just say to you, understand that no court yet has ruled on this. No court has considered this. And, I would hope that at the very least, if you're looking for an objective standard that you can understand, perhaps a court will question the wisdom of this. But we'll see.
We will.
Yeah.